Hey guys, welcome to my channel. If you enjoy watching and want to see more, don't forget to subscribe. I share videos that are helpful and easy to understand.
Can a sex offender get off probation early? This is a common and critical question. The answer is yes. It is technically possible. However, it is an extremely rare occurrence. It is also incredibly difficult to achieve. Courts prioritize public safety above all else. Sex offense probation terms are usually very strict. They are also typically quite lengthy. Early termination is not a common outcome for these offenders. Several factors determine if early release is even considered. The offender must demonstrate impeccable compliance with all probation terms. This means absolutely no violations whatsoever. They must successfully complete all mandated treatment programs. Sex offender-specific therapy is almost always a requirement. Psychological evaluations will assess their current risk level. A significant and verifiable reduction in assessed risk is crucial. Their probation officer's recommendation is vitally important. A positive report from the probation officer carries immense weight with the court. The sentencing judge holds the ultimate discretion in these matters. This judge must be thoroughly convinced of the offender's complete rehabilitation. They must believe there is no longer a public safety risk. The severity of the original offense plays a major role. More serious or violent offenses make early termination far less likely. Some states have specific statutory limitations. These laws may prohibit early release for certain severe sex crimes. Even if early termination is granted, sex offender registration often continues. This registration can be a lifetime requirement. It is a separate legal obligation from probation supervision. The process usually involves filing a formal motion with the court. An attorney typically files this motion on behalf of the offender. A hearing is then scheduled before the sentencing judge. The offender must present compelling evidence to support their request. This evidence includes completion certificates from all treatment programs. It includes positive and recent risk assessments. It includes glowing reports from their probation officer. Prosecutors almost always oppose these motions vigorously. They argue for continued supervision to protect the community. The court carefully weighs all presented evidence. They consider the original crime's nature. They consider the offender's conduct throughout their supervision period. Public safety remains the paramount concern for the court. The victim's perspective may also be heard in some jurisdictions. Early termination of probation is not a right. It is a privilege that is rarely granted. It is only considered in truly exceptional circumstances. The burden of proof on the offender is exceptionally high. The offender must show complete personal transformation. They must show a sustained period of exemplary good behavior. They must unequivocally prove they are no longer a threat to anyone. Public sentiment against sex offenders is very strong. This public opinion often influences judicial decisions. Courts are extremely cautious in these cases. They are hesitant to release sex offenders early from supervision. The legal standards for early release are very rigorous. The entire process is lengthy and intensely challenging. It requires consistent effort and perfect adherence over many years. Thank you for watching. Please like this video and subscribe to our channel for more legal insights.
Thanks for watching. Please like and subscribe.